Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I am very excited to tell you that we have on the show this week attorney Nicole Reeves Lavallee. She has a family law firm out in the Worcester area, and she is here to talk to us today about modifications. Welcome, Nicole. Thank you so much for joining us.
Thank you. It's a pleasure to be here. And again, this is one of those topics that always comes up and no one really knows what to do.
Yeah, I mean, gosh, you go through this incredibly long and painful process, not if they're working with you, of course, but divorce is painful even when you have the best attorneys and even when you have spouses that aren't fighting. It gets painful at different times, surprising times. Then you finally get through it all. And for some of you poor people out there that have suffered through the pandemic and have had even longer wait times and maybe even been stuck in the house with your ex, yikes, you get through that divorce and 6 months, a year, somewhere down the line, you get a request for modification. So why don't I let you tell us the definition of a modification?
So modification is going to happen anytime you have a judgment. So it could be a judgment on divorce, judgment on a paternity, judgment on custody, any of those things. So once you have that judgment, it's basically exactly what it sounds like. You want to modify that. You want to make changes to it. For whatever reason, that judgment no longer works for one of the parties. So we need to make a change to that judgment. And the way to do that is by filing a complaint for modification with the courts.
Wow. I mean, it sounds serious. It sounds like change. Nobody likes change. Somebody is going to be unhappy, I'm sure, with whatever the modification is. Can you tell us what types of modifications we're talking about here?
Oh, there's so many. So the biggest ones are going to be child support. So I lost my job. I don't have a job anymore. I'm out on disability. I can't afford $200 a week. Oh my God, what am I supposed to do? Rather than getting in arrears, you want to file a modification. You have issues with the parenting schedule. It no longer works, such as right now when we're going through COVID and we have remote learning. So does that parenting schedule work when the one parent who has a child half the days of the week can't take care of the schooling? Probably not. So there's going to be changes in your parenting schedule just by life-changing events. Those things are going to come into play. You could do it for just tweaking the schedule. So sometimes it's maybe just the holidays don't work, or worse yet, your attorney didn't put in anything regarding holidays or summers. That's a huge issue because guess what? At some point, you're not going to agree on that. And the best way to do it is to go into court and ask for a modification to change it, or in this case, to add it. You will have issues regarding custody. Maybe, unfortunately, one parent became an addict or is having mental health problems. Or, I've even had cases where somebody has unfortunately gone into a coma. Obviously, coma patient can't take care of the children. So those are kind of the big issues. And then obviously you have the little issues of, I lost my health insurance. Should I change that? I can't afford the life insurance anymore. Should I change that? So those are kind of the other little things. But now, any modification or any judgment isn't going to have things pertaining to a college unless your child is of college age when you enter into that judgment. So your child's 8 years old now. In 10 years, you're going to ask for a modification so that you can change language in the agreement that says what that parent is supposed to be paying for college education. And certainly in that time frame, chances are your incomes as well as your spouse's income has changed significantly. The biggest one, which is probably the most contentious, is going to be alimony. So nobody wants to lose alimony, and the other person always wants to terminate alimony. And so that's the one that it's very difficult because there's no fine line. We're not dealing with the children now, we're dealing with two adults. And we really have to look at the facts of the case and determine whether it's warranted. But that's probably the hardest one because the other ones are very easy when we figure out what's in the best interest of the child.
Wow. I mean, and I will say this, we can say it now. You helped me through my divorce. So I am a great testimonial for you. And I remember that, during the process, you really pushed for putting things in paper for the holidays and, what days we were going to have the parenting time. And at the time we're like, oh, we're fine with that. We work it out. It's great. But you said, just in case something happens in the future where you are not so friendly, you should get these things in writing. Not that, we would ever not work with each other on certain things, but you really helped us plan for the future and not the very moment we were in, because you had the foresight to know that these divorces, people go through a whole range of emotions, and they might be fine now, they might hate each other, and then they might come back around. Hey, some people get remarried. So, there's a lot of things that could happen. And, that's why you have to have an attorney help you through this stuff. And, trying not to have modifications, trying to avoid that is good, but you can't always avoid it. You must see a lot of situations where people are completely shocked by modifications that come up. I mean, you mentioned coma. There's lots of things that life throws at you that you don't always expect.
Yeah, there's so many instances. I mean, obviously, like I said, the big ones are I've lost my job, or somebody becomes an addict, or relapses that was an addict that was doing really well for 10 years or so. So you have those issues that come up, and then you have the ones that you're going, oh my God, I never foresaw that. And you just can't plan for these things. So, my job as an attorney is, when I do the judgment, to include all of those things, because the ideal goal is that you never come back into court. But that's the reason why the modifications are out there, so that if and when you need that change, because there's something that's going on in your life, you have a remedy, you have an availability to do that.
Well, that makes sense. So if you did have a modification that you wanted the court to consider, when should you bring that up?
Well, it all depends on what you're looking at. So if you're dealing with child support, it can be brought up when there's a change in circumstances. It has to be a substantial and material change in circumstances. What that really means on paper is somewhere around 15% increase or decrease. Or if it's not in accordance with the guidelines. So, somebody won $1 million and they're a millionaire now. Great, congratulations to them. But guess what? As a result of that, we need to recalculate it, because obviously there's going to be a change in circumstances. Obviously, again, the other end of it is losing a job and we don't have that money, and we're on unemployment or we're on disability or things of that nature. So it really depends. In terms of the parenting schedule, that's obviously a little more touchy-feely, because we don't know what that looks like. We don't know what happened. We need to be able to show something happened. And again, it could just be that we as parents cannot agree on a schedule. We as parents don't think the schedule is working. Maybe it's, the child's coming home exhausted on one parent's parenting time, and so their school work is suffering as a result of it. It could be something like that. It could be, that one of the parents did get remarried and they're not either caring for the child properly, or the step parent is unfortunately mean to them, or things of that nature. So it really depends on that. Again, that touchy-feely. What does it feel like? Does it look right? Is it, tell me something. And unfortunately, that's kind of where I have to go with clients, is tell me what's happening, because I don't know if you qualify in a custody situation unless I can understand what's going on. And sometimes that gets very ugly and people don't want to divulge that. But at the end of the day, it's something that I need to know, because I can't make a decision for you and I can't tell you and advise you if we don't know what the facts are. Other cases, it's, cut and dry. I lost my job, and as a result, I lost my health insurance, and I can't be obligated to pay for either my ex-spouse's and or my child's health insurance. So I don't want to be held in contempt. I need to change it. Those are probably the easier ones, because either the other parent will pick it up, or we're going to agree that maybe Mass Health is the appropriate person to ensure this child and this family. So there are certain things that are relatively simple. But then there's other cases that, again, if you go back to that alimony, it's going to be contentious because nobody's ever met the criteria. It doesn't matter. Whichever side you're on, you're never going to agree to the change. And unfortunately, those are the cases that usually end up either going to conciliation or to trial.
And it sounds like some of those situations could be he said, she said, and that makes it just makes it tough to prove unless you have like recordings and I guess testimony from the child, if it's a situation where the child is being abused in some way, mentally, physically, neglected, all of that. So, I mean, that's very sad. Now, if something like that is happening, you really need a modification fast. Or if you need any modification at all, what is the time frame for getting a modification to be put together?
So in terms of filing the complaint for modification, that's relatively quick. We can file that within a week's time frame, if not sooner. Sometimes it could even be the same day. The issue is that we're waiting on the courts to do what they need to do. But bottom line is there's an 8-month tracking order, which basically means that your case should, from beginning to end, should finish within 8 months. And when I say should finish, one, it's obviously a should, not a mandatory. And two, it is basically what the courts are gauging it on. On a regular case, an average case, they think from start to finish, final judgment, not temporary orders, it's going to be approximately 8 months. And again, that's a guideline. That's not COVID issues. That's, having the courts back to normal schedules. So again, we start with that. Now, can we get you into court on an emergency basis on a modification? Really depends. We're going to have a higher burden. Chances are we really have to show something's happening. So say, for example, like you just had mentioned, was abuse or neglect. Well, if DCF is involved and DCF is saying, hey, you know what, at this time, mom shouldn't have parenting time. Well, obviously, if I'm representing dad, I can go into court and I can certainly say, this is what needs to happen. Here's the answer. Go talk to DCF. They're going to talk to DCF and they're going to go, maybe depending on the circumstances of the case, we shouldn't be doing this. But again, if it's just, hey, mom's really not treating the child right, or again, the child's sleepy and okay, great. That's not going to end up in a temporary order. You're going to most likely have to wait the entire length of the case. Again, I lost my job and I have no money right now. Maybe I can get an emergency hearing, but it would be on a temporary order, and then we'd still have to play it out because, again, maybe you do get a job within the next 8 months and we don't want you to come back again, or mom or the other party to come back again and say, hey, now we need to increase it. So they'd rather give you a brief time to see if we can get a job or see if we can, get those issues resolved. So again, kind of looks at the big picture of what's going on. Is there an emergency? If there's not an emergency, you're not going to get temporary orders, and you're most likely going to be on that 8-month track.
That sounds like a long time to wait when you have a situation. I'm glad that they have some emergency possibilities for you with temporary orders. So what happens in the 8-ish month?
So basically what happens is we're going to do the exact same thing we did in your first case. So whether it be a paternity or a divorce case, we're going to do discovery. We're going to gather that intel. I have one case right now where, unfortunately the child is being put on medications and one of the parents disagrees with that. So what are we doing? We're gathering the information. We're subpoenaing the records from the medical professionals. Why does this child need to be on this medication? Is this the appropriate medication? Is there things that are happening at one or both parents' houses that are warranting it? Is one of the parents, for lack of a better word, kind of coercing the doctors into saying that this is what's going on? So those are the things that we need to look at. We're going to gather the police reports. We're going to gather the school records and the things of that nature that says, hey, look, this child needs to be on this medication. There's a no ifs, ands, or buts about it. So whether we're representing mom or dad in that situation, we still need to know who's got the better information, the better documentation to support their position. And then once we can know that, then we can have a sit-down discussion and say, okay, so now that we know this, maybe it's true, maybe it's not. But now that we know this information, how do we resolve this? So it's in any type of case, even if it's, again, I lost my job. I want to know if you look for a job. I want to know each and every place that you've applied for. I want to know why you lost your job. Was it because you were sleeping on the job and you're a security guard and you need to be awake? Those are the things that are important. So I need to look at the big picture as to why this change happened. What documentation can we gather to show that it's either helpful or hurtful to our client, so that we can educate our clients to make the best possible solution in their case and enter a judgment.
Yeah, well, I mean, that sounds like you really know how to tie up the process there, and you take into consideration everything that can change over those 8 months. It makes a lot of sense when you explain it that, it could take a little bit longer, just because people do lose their jobs and they get new jobs, hopefully. I mean, right now it's kind of a crazy circumstance during this pandemic, but if we're looking at this information as kind of evergreen in the past, and for most people, you can go out and get another job, and it might take you a couple months, but you should be able to get another comparable job depending on what happened. Like you said, there are other circumstances, people that get stuck on drugs, people that fall asleep at their job. Like there's definitely a lot of situations where maybe they don't get the forgiveness that they would get, and they're made to continue paying what they normally pay, or they're made to give up some of their parenting time because they're not really using their parenting time the right way.
And I mean, like I said, there's so many factors, there's so many reasons of why we need modifications. But again, the question is, again, if it's not that emergency, we need to do our due diligence. We need to understand the circumstances. We need to be able to educate and kind of move forward. And, with some of that is that emotional, I need to file right now mentality. And sometimes that's not what's best for either of the parties, yet they go and do it. And a lot of times that's, the pro se litigants, that I want my day in court and I'm going to do this because I said so and I'm right. And then when they either hire an attorney later on, or you listen to the judge and the judge says, where did you get this idea that this is warranted? And the other party's, of course, spending lots of money defending it. It's one of those things that there has to be consequences to it. So we need to look at big picture of why are they doing it? What's the motive? And what are the consequences to those actions? Because at the end of the day, a lot of times they will settle. And just think about this, is that before you file a modification, depending on how you get along with that person and depending on the circumstances, you might be able to just either go to mediation or even file a joint modification. It does happen. It's amazing, but it does happen. People do get along and they can file modifications jointly. And so that's another way to save time and money if that's something that you can do.
And those are the same couples that go to lunch and celebrate after their divorce papers are signed.
Absolutely.
I always think that's so interesting. So is there anything else we should know about modifications? Any, interesting gotchas that you've seen in the past?
I think the biggest thing is you just can't run into court. If you're one of those people that, I call them the cry wolf people, that are constantly running into court and saying, he did this and he did this and he did this. And great. Guess what? When you have a modification that's dismissed, and another modification that's dismissed, and a third one, at that point in time, if I'm representing the other party, I'm going to go ask the court for sanctions against you. I'm going to ask that, there's fees and penalties. And then more importantly, somebody at the court has to approve you to even file this, because now you're just abusing the system. So there are people out there that think that, well, I'll just do it. And they'll do it because they're not paying an attorney. So they've got free services. They can use the court however they want. No. You have to understand that there's consequences for that, and I've been very successful in stopping those people from doing that, because again, it's just abusing the court system, the court process. It's running up unnecessary legal fees, and at the end of the day, a lot of times I've been allowed to get my attorney's fees paid as a result of their actions. And guess what? That's usually when they stop doing that for a really long time, because they never want to pay the other party's attorney's fees. So just be cautious, use it reasonably. If you need it, absolutely, that's what it's there for, but don't take advantage.
Yeah, that's definitely, court is not the place to get revenge, because people do catch on to that. I mean, the judge, the attorneys, and you do end up having to pay the other person's fees if you're being unreasonable.
Absolutely.
Well, I want to thank you so much for coming on the show again. You're always so kind with and generous with your information and your time on Friday afternoons. We're looking forward to talking to you next week. And if anybody has any questions at all about a family court case, please pick up the phone and give Nicole and her team a call. They know what they're doing. They are right on the cutting edge of any changes that are happening, especially right now with the pandemic. And they've got fantastic strategies that are meant to help you get the best outcome. And even more importantly, if you have children, get the best outcome for them. So I want to thank everyone for listening. Thank you, Nicole, for coming on. And we will see you next week.
Thank you.